Welcome to Beyond the Code, the podcast where industry experts and brilliant legal minds discuss the impact of new emerging technologies. I'm your host, Yitzi Hammer, a lawyer and tech enthusiast. Join us as we explore the legal, regulatory, and ethical issues surrounding AI, blockchain, and more. Get ready to go beyond the code and stay ahead of the game. Thanks for joining me on another episode of Beyond the Code. Today I'm joined by Professor Brian L. Frye, a securities lawyer, a contemporary artist, an AI enthusiast, a professor of law, and an expert on intellectual property and charity law, among others. In short, an expert on many of the fields that this podcast purports to explore. Brian, I'm super excited to have you here today, but given your varied interests and areas of expertise, I just don't feel qualified to introduce you. So if you don't mind, how about you shortly introduce yourself to our audience?
Well, thanks so much, Izzy. It's a pleasure to be on the podcast, especially as one of the first guests. So yeah, I am currently professor on the faculty of the University of Kentucky College of Law, although this semester I'm visiting at Tulane Law School. Before going into legal academia, I was, primarily a securities litigator at Sullivan and Cromwell in New York City for several years, and went to NYU Law School. And like many securities lawyers, before going to law school, I also attended art school at the San Francisco Art Institute, where I did an MFA essentially in conceptual art. And that's informed a lot of my legal scholarship going forward. So my scholarship and teaching focus primarily on intellectual property, especially copyright and trademark law, as well as elements of legal history. In the course of the last several years, I've gotten really interested in the Web3 environment and specifically in the NFT market, which is a lot of crossover with my interests in the conventional art market and how it functions economically. So in a nutshell, that's where I'm coming from. I write a lot for law review articles. I also write a lot for popular media. So recently I've been publishing a bunch of shorter pieces, essays and op-eds and whatnot with CoinDesk, Right Click Save, Outland, and other outlets like that.
Thank you for that. And I just have to say, I love your mind. Like, I love everything that you write. I totally can relate and connect to you on a lot of different levels. I feel like you explore a lot of the ideas that I a light bulb kind of came out of my head, and I'm like, oh, I'm going to put that somewhere in the corner. And then a couple weeks later, I see you writing about it. So I think we're very much in tune in that sense. And I have to say, just also to share with the audience how I kind of stumbled upon your work. And also, I kind of owe you an apology. Last June, I was asked to come and give a lecture at ETH Paris on NFTs and copyright law. And since you're, an expert in the field, I obviously came across your work and the work of Alfie Steiner. And I quoted you extensively in my lecture and in my presentation, but like an idiot, I kept referring to you as Professor Philip Frye for some reason. I don't know why. I think it just got stuck on the fa. Like the Frye thing I was just rolling with it. So I kept saying Professor Philip Frye, Professor Philip Frye. And then a couple of people were watching the video afterwards on YouTube, and they're like, we've heard of Professor Brian Frye, who writes a lot about this area, but never Philip Frye. So maybe you got that one wrong. And I'm just like, oh man, I feel terrible. And I right away wrote you and apologized. So I'm now apologizing to you live, so please accept my apology. But after that, I kind of just became a major fanboy and started following you on Twitter and watching videos, listening to podcasts, and reading your works. And I love everything that you write about. It was kind of difficult for me to determine where I wanted to start today, where I wanted to talk about. But I think that the best place to start is you're one of the most entertaining academic scholars that I know. You actually proposed to your wife via an academic article, and you trolled the SEC through various academic articles that you minted as NFTs and did a whole bunch of other really fun stuff. So is academic scholarship at risk as a result of ChatGPT? I know I've seen a lot of concern, specifically from the science community, of how are we going to keep ChatGPT-esque scholarly works out of our journals. And then I think, again, something else that you tweeted on the other side, some scholars were saying, well, now we could actually focus on like the really interesting stuff and the research, and not on like writing rubbish that the AI could do for us. So what do you think?
Yeah. Well, so first, apology accepted. I love everything about that. I'm delighted to be Philip Frye for the day. Wonderful, wonderful. It's absolutely perfect. So yeah, I think that's a great question. I have done a lot of more idiosyncratic work that I frame as legal scholarship. When I got tenure and started thinking about what I wanted my career as a legal academic and legal scholar to look like, one of the things that bothered me the most was that legal scholarship, and I think, frankly, academic writing in general, is an incredibly banal literary form. Right? We have this kind of format that people use that doesn't allow for a great deal of literary expression or creativity, and we bind ourselves to it for no particular reason. I mean, especially for legal academics, we can write anything we want to, and yet we don't. We typically tend to write the most sort of conventional, generic type text possible, focusing on the content rather than on the form. And so a big part of what I wanted to do was think about how to kind of activate the medium of legal scholarship and think about it as a literary form, not just a container for content. Specifically, I decided at a certain point that I wanted to do was to try to create conceptual art in the medium of legal scholarship. And so transitioning to that, into your question about ChatGPT, I think it's actually kind of sad that people are so scared of it, because it underscores the extent to which so much academic writing is so generic, right? I mean, think about it. The reality of ChatGPT is it's just a mashup machine, right? All it can do, all it's designed to do, is to look at the corpus of texts that exist and give you the most average possible response to whatever question that you ask. It's not thinking, right? It's generating conventional wisdom. It's literally a machine for producing conventional wisdom. If you as an academic, or you as any other kind of art author or artist, can't compete with ChatGPT or some other LLM, AI,
What are you even worth?
but yeah, why are you bothering? Right? What you're saying is that what you're producing is utterly conventional, right? That's kind of pathetic, right? So, I mean, to my mind, we as academics should be excited about this, because it'll screen out a lot of what's not worth producing, what's not worth looking at, what's not worth paying attention to, and encourage us to focus on the content, what we can add that's better than conventional wisdom, what we can add that isn't already out there in circulation. If ChatGPT can do what you can do already, then you should maybe find something else to do.
Yeah, I think you're 100% right. I think all ChatGPT is doing is regurgitating generic content. Then it should really make the scientists' work easier.
Yeah. I think that's right. I've already used ChatGPT to write a law review article, and it worked pretty well. But what was interesting about it was how uncreative it was. What was mostly interesting to me was, when I tried to say something radical or ask ChatGPT to say something radical, it just flatly refused. Right. So a lot of my scholarship, what kind of one branch of my scholarship, is sort of what I refer to as kind of an apology for plagiarism. Right. So I like to describe myself as the most prominent plagiarism apologist in the legal academy. I'm also the only one, right? It's very easy to be first in a field of one. So I wanted ChatGPT to produce an article for me that argued that plagiarism norms were illegitimate and that plagiarism is a good thing. And it just refused. Right? It could not produce that text, because the corpus of texts out there discussing plagiarism is, 99.999% plagiarism is really bad. Right? So a large language model working with this corpus of text doesn't have anything to work with when you ask it to make an argument going the other direction, all it can do is regurgitate the kind of conventional wisdom, unthinking condemnation of plagiarism as being bad. It doesn't have a reference to criticize that perspective. And I think that that's kind of the fundamental weakness of ChatGPT. It's fundamentally incapable of doing anything that we could meaningfully call creative. And that's actually one of the things I think is most interesting about ChatGPT from a copyright perspective, right? So we like to say that copyright is about encouraging people to produce creative works, but we never really think about what we mean by creativity, or how we go about, or how we ought to go about differentiating legitimately creative from uncreative works. We never really had a model or a way of testing that. I actually think ChatGPT is perfect for that, because all you have to do is reverse engineer it, right? By definition, ChatGPT is incapable of being creative. Therefore, why not use ChatGPT to evaluate works produced by people to determine whether the people have actually produced something that's creative, or they've just produced something generic that's not deserving of copyright?
Yeah, I mean, I think OpenAI is one step ahead of you. I just saw that they released a product that basically will scan the works and tell you if there's like a high, medium, or low chance that the work was generated from an AI. So it's probably just that reverse engineering that you're talking about.
It's super easy. No question they can do it. The only problem is we need to embrace the reality that the machines can tell us
I agree.
when we're actually acting.
Yeah, I think you minted an NFT of that the output of the AI to your plagiarism request,
Yes,
right? Where it basically like sort of self-destructed on itself.
Yeah.
Yeah, that's pretty brilliant. I love how you're like messing around with all those things and just kind of like meshing them together. And I know that there's a new form of plagiarism, which I believe that the academic scholars are calling AI-gerism, which is basically just scholars that are claiming that AI outputs are their own scholarly works. So it's fun to see how AI is innovating in the plagiarism venue.
Yeah. Well, I'm hoping that these AI machines encourage people to complicate what they think they're doing and what they're talking about when they refer to plagiarism, right? Because one of the things that I've noticed as a scholar of the history of plagiarism norms, as it were, is that the level of discourse around plagiarism is depressingly superficial. I mean, it's so uniformly negative that there's no room for criticism of the assumptions that are made institutionally and socially about the wrongness of engaging in whatever gets classed as being plagiarism, to such a degree that there isn't even a coherent definition of what constitutes plagiarism in the first place, and is almost entirely a context-specific accusation, right? So an activity that would be obviously plagiarism in one context is considered perfectly normal in another. I mean, the legal profession is a great example, right? I always like to say, in the practice of law, if you're not plagiarizing, you're committing malpractice, right? Because, especially from a transactional,
I was going to say, give me an example, but that's a perfect example. Yeah. I mean, ultimately, everybody's taking the same draft and tweaking it to the benefit of their client.
And they should be. Imagine how you would feel as a client if your attorney came to you and said, well, we had a really great precedential agreement available, but I didn't want to copy it because that would be plagiarism. So instead, I drafted an entirely new agreement from scratch. Here you go. Here's a bill, by the way, for the 20 hours I spent writing it. Also, we have no idea how any of these provisions are going to be enforced because a judge has never seen any of them before. But, it's not plagiarized, so it's great. Right? And then
that's brilliant.
Right? And then
brilliant. It's so true.
And then the same with a brief, right? I mean, you come to a client and say, well, I didn't want to plagiarize this perfectly serviceable brief, so I rewrote it from scratch. Here's a bill, and who knows if what I've done is as good as this other brief that's been used by 30 or 40 other lawyers successfully on behalf of their clients, right? And then think about what judges do, right? I mean, literally every judicial opinion that gets released is straight up plagiarized from the law clerks. We just don't call it plagiarism.
Okay, so that's one industry. Give me another one.
I mean, think about ghostwriting, for example. We kind of frown on it, but it happens constantly, right? And is perfectly accepted.
But it's not plagiarism.
Sure it is. Ghostwriting is absolutely plagiarism.
Well, the assumption is that the ghostwriter didn't plagiarize the work from
Yeah,
somebody
but
else.
the
It's the
person,
original authorship of the
yeah,
ghostwriter.
but the person who put their name on it did not write what they're claiming to have written. That's plagiarism.
So what? If I write under a pseudonym, are you saying that I'm plagiarizing myself?
Well, no, because if you write under a pseudonym, then it's properly attributed just to you. It's sort of like if you're using a brand, right? And the consumers know that it comes from this brand. They just don't know the actual source of whatever is being produced. But I put it another way, right? I mean, so if on that theory ghostwriting isn't plagiarism, then an essay mill isn't plagiarism either, right? Because there, it's the essay mill is in the role of the ghostwriter producing the text for the student, who then puts their name on it and submits it to.
Well, an essay mill is just
No, I mean,
ChatGPT, less
I know from
sophisticated.
personal experience that essay mills actually produce text. Ask me how I know. Well, I commissioned essay mills to write law review articles for me, which were then subsequently published. I mean, I did disclose the entire process because it was part of what I was doing. But the person I commissioned it from definitely sat down and wrote an original. I mean, it wasn't that original, but it was written by somebody. I could tell because it wasn't particularly good, right? They also didn't satisfy. I mean, this is like, again, really. I love that they didn't satisfy the prompt, right? So I asked the essay mill to write me an essay explaining the illegitimacy of plagiarism norms. And the person at the essay mill, Alvin Imudu was the first one. He wrote me an essay explaining why plagiarism is bad, which I just was like,
So he didn't
he
fully
didn't
understand
fully.
what you were
He could.
asking
I
him for.
think maybe he didn't understand. He couldn't fully accept that I would be requesting an essay of that kind, but also the idea of somebody at an essay mill producing an essay about.
Who is plagiarizing and is explaining why plagiarism. Yeah, I love it. And that's what you do, right? Like you just find these like weird, quirky things that you find that you think are
Yes,
funny,
yes.
and then you
Well,
just roll
and
with it,
yeah, and the
right?
thing, and I think the key point for me is it's one thing to explain these ideas in kind of conventional academic form. I actually think it's much more effective to show what it looks like, right? So I can sit down and write an article explaining why I don't, and I have written articles explaining why I think plagiarism norms are incoherent. But doing a project like that is sort of an illustration of the incoherence that I think is richer than an explanation in kind of a kind of conventional explanation could ever be. Kind of operationalizing it and turning it into a performance makes it more compelling, at least to my mind.
Okay, so we've been talking about a lot about text. Let's move on into imagery. Okay, you're a contemporary artist, or what do you usually twist it around? You say that you're a contemporary lawyer and a
Yeah, I like to refer to myself as a conceptual lawyer and securities artist.
conceptual lawyer and securities artist. I love it. So you have background in creating various forms of art, both movies, right? You produced a bunch of movies.
Yeah, so I mean, I went to art school in the mid 90s, and I was primarily interested in the kind of new American cinema, American avant-garde film, which is sort of a crossover between motion pictures and conceptual art, essentially, right? So sort of a very kind of minimalistic filmmaking style where ideas that were au courant in conceptual art in the 60s and 70s were sort of translated into a motion picture medium. So that's kind of the context in which I initially primarily worked in film. I did produce a kind of a feature documentary film called Our Nixon, which was directed by Penny Lane and was premiered at South by Southwest. It showed on CNN. It's done pretty well. It's still on like Amazon and all that kind of stuff. So you can watch it for free. More recently, I've kind of reframed my artistic practice to sync up with my scholarly practice more. It's like I said, I've kind of been focused more on sort of using legal scholarship as a medium for artistic activity. And I actually really like it because I kind of feel like the less promising the medium, the more fun it is to try to transmute it into a means for engaging in artistic practice. And there are few media less promising artistically than legal scholarship. So, it's a challenge, but I love it.
Okay, so but we talked about text. Now we're transitioning over to film and imagery. What are your thoughts? I know your thoughts already, but I wanna talk it out. I want to talk it out with you on generative
Mm-hmm.
artwork. How do you determine from a copyright perspective specifically what is, I guess, sufficiently unique, to coin the SEC's term, in the creation of generative art? Like, whose is it? What is it? What protections does it deserve? What happens when you buy a Bored Ape or a Punk? What could you do with it? What can't you do with it?
Yeah. So I think there's actually two questions bound up in there. One of which is kind of a copyright doctrine problem, which I find kind of intellectually interesting as a copyright scholar, but I think ultimately may be the less interesting question in a market sense. Because I think actually the bigger question is what the market actually wants and what it actually ultimately values, what the kind of fundamentals of the NFT market really are.
Okay, so not all of our listeners have a technical or legal background, so I just want to explain for 1 second what exactly we're talking about. You have copyright and you have trademarks. Trademarks are sort of registered marks that give you the rights to certain images or terms, like the Nike logo or the Nike name. While trademarks need to be registered in order for them to be protectable, copyrights don't need to be registered. For example, if I write a blog piece or an article, it's copyrighted inherently by virtue of me having created something that's new and unique. But there are certain things that are not sufficiently unique and are therefore not protected by copyright. For example, the US Compendium on Copyright Law says that in order for something to be protected by copyright, it has to have been created by a human being. So there are still many things that human beings create, but computers contribute to. So it's a question of how much was created by the human versus how much was created by a computer. When we're talking about art that's generated by an AI, especially if it's pixelated or if it's a generative collection where it's creating 10,000 pieces of a scramble of 20 different items, then it's hard to argue that this is sufficiently unique in the sense that it was created by a computer but aided by humans. So when I ask if it's sufficiently unique, this is what I'm referring to.
So, from a copyright doctrine sense, right, essentially the big problem is copyright doctrine doesn't really have tools to deal with what people are doing when they create generative artworks. It hasn't really, copyright doctrine is relatively old, hasn't evolved all that dramatically in sort of a statutory sense. And I think courts are kind of slow to adapt broader, more abstract provisions to new technology. So I think that the two big issues that both I and Malfi Steiner have identified are, one, this initial question of copyrightability. Right. So I wrote a paper titled Are CryptoPunks Copyrightable? And the kind of the premise of that paper was that it's very difficult, I think, to locate the originality from a copyright perspective with respect to any particular CryptoPunk image. Maybe collectively there are enough kind of choices that are made that the Copyright Office could recognize the corpus of 10,000 CryptoPunks or whatever as being a set of sufficiently creative decisions in the aggregate to constitute a copyrightable work of authorship. But when it comes to any particular image, they're very small 8-bit images, so they're pretty stripped down to begin with. That's rough from a creativity perspective. What's more, a lot of the images are pretty generic in the sense that I identified in the paper like previous pixel art that used very, very similar images to the CryptoPunks images, right? Which is unsurprising, right? Because the CryptoPunks images were intended as a kind of homage to 8-bit video games of the 70s and late 70s and 80s, right? The kind of the very nostalgic sort of feel. What's more, the generative aspect means that individual elements of each CryptoPunk are really, really small, often consisting of only a few pixels. And there's just no way that copyright can protect an element of a work that consists of only a few pixels. So, I think there's a kind of open question about whether the CryptoPunks images are even copyrightable subject matter in the first place. I could see, a court or the Copyright Office going either way on that, but it's unusual in the sense that it's typically really easy to know whether or not a work is copyrightable or not. In the case of the CryptoPunks, I think it's hard. Alfie pointed out a sort of different problem, which is that when you're talking about the copyrightability of a particular image, you've got to differentiate it from all the other similar images. And when it comes to the Bored Apes, for example, right, in the abstract, they seem pretty clearly copyrightable, right, because the level of detail and content, even in the individual elements, is considerably higher. Copyright doesn't expect that much. So, I would say in the abstract, even the elements would be copyrightable. The problem is that you've got all of these different variations on the same elements. Well, how do you differentiate one Bored Ape image from another Bored Ape image?
Especially when they might have the same background, same
That's right.
imagery,
And
except
as
for
like,
an earring in one
exactly.
case
And
or
as
a
Ryder
hat.
Rips has pointed out, there's like a lot of the Bored Ape images where the only difference between one image and another is a different colored background. Well, those are the same image, right? You can't have multiple copyright owners, right? Or you can't claim,
especially given that most of the people who are using the IP for commercial use are removing the background as it is. So then you really have no distinction.
They're literally the same image. But I think that kind of gets us to what I think is more interesting, right? Because for better or for worse, lawyers and law.
Right, so that was my question on this sufficiently unique.
So I mean, like, I think that the Copyright Office would very likely look to the Bored Ape images in the aggregate and say that these elements are copyrightable, and therefore Bored Ape as the creator, or rather Yuga as the creator of these Bored Ape images as a work made for hire, presumably, could be the copyright owner of them in the aggregate. Right. I think there's an open question about what, if anything, they're actually conveying by way of a copyright interest to the NFT owners who they're purporting to give a license. Maybe they're just giving the same non-exclusive license to a bunch of different NFT owners who own very similar or identical NFTs of very similar or identical Bored Ape images.
Right. The issue comes when you tell your community, okay, you bought these NFTs, now we want you to take them, build on the IP, commercialize it, start your own multi-million-dollar companies that are centered around this IP. Yeah. When I don't even know if I can give you those protections. Like, is the IP even mine to give to you? And if it is it sufficiently different than what I've licensed already to somebody else, so that if you go out and you have a chain of restaurants using your ape and somebody else has a makeup line using their ape, who's to say what the distinction is?
That's right. And I think that actually gets to what I think the more interesting question from a practical standpoint is, because I actually think the use of the term IP or the use of the term commercial rights is really unfortunate, because it's quite misleading and confusing. From a doctrinal perspective, from a legal perspective, really, I think it's critical to distinguish between copyright and trademark interests, because they're totally separate and they go to different value propositions. And at the end of the day, I think, especially when it comes to the large generative PFP type collections, the value is not in the copyright, the value is in the trademark. That the value is in the brand, not in any particular, not in kind of control over any particular image. In particular, when it comes to something like CryptoPunks.
Yes, but but the brand creates goodwill that's associated with each of the copyrights. Because if I want to build a company around my ape, then yes, I cannot draw on the trademarks that belong to Yuga, such as Yuga Labs, BAYC, or anything else that's associated with the collection. But there's no question that the goodwill of my ape and my ability to use it will be drawn from the success of Yuga in, raising $400 million and a $4 billion valuation, and developing and launching the other side, and all these other kind of things that they're doing on top that are dripping down, and that goodwill is enabling me to build around my singular NFT image, which is resounding in copyright, but drawing on the goodwill of the trademark.
This is, I agree to an extent, but I actually think that this is where the problem really comes in, because my intuition, based on personal experience, right, is that when consumers see a generative image like a CryptoPunk or a Bored Ape image used in a commercial context, right, they see it as emblematic of the larger brand, CryptoPunks or Bored Ape, not of a particular source. Right? I think it's difficult for most consumers to meaningfully differentiate between different images from a very large collection like that. And so each one of those images, functionally speaking, is a representation of the larger brand, even if you're not directly using the word mark or even, specific.
You're referring to layman consumers. In other words,
Yes.
not somebody from within the Web3 community who would easily identify, Punk 6529 with his own
Sure.
work as
Sure,
opposed to.
but even when it comes to that, right, I would say like, look, I would vaguely know like, oh, that looks pretty close to Punk 6529, but there's a halo around it of very similar Punk images, which I wouldn't differentiate those from that particular image, right? So I mean, like, and to
Interesting.
the extent that Punk 6529 is associated with that particular CryptoPunk image, that's him. Bill, I'm presuming him building goodwill around that particular image and engaging in the branding exercise himself, not just drawing on the goodwill of CryptoPunks. In other words, I think that there's independent goodwill developed in relation to the brand imaging that didn't happen.
Absolutely. But it works both ways.
Right.
I mean, the power of
Oh
the
yeah,
community can be drawn back up to the founders and vice versa. In the same way that the founders, if they do something shady, then it will have an impact on the community members on their own respective
100%.
IPs.
But I think that there's
So we're all one big happy
but
family.
I think that there's a lot of kind of unresolved questions about how that really works in practice, right? So like the example I like to go to because it's such an obvious one, right? Is imagine you choose to use your Bored Ape Yacht Club image to promote your burger restaurant, right? Now, you're permitted to do that by their license, although what you effectively have is a non-exclusive license to use that image or the images of related to the NFTs you purchased in a commercial context. Imagine somebody in another part of the country, right? Imagine you're operating your burger restaurant in Long Beach, California, and somebody else decides to open a Bored Ape Yacht Club themed burger restaurant in New York City, right? Nothing about the licensing terms is preventing them from doing that, right? But I think that it's
But it would have to be with their own ape. It couldn't be with
sure,
mine.
right? But my point is,
So in that sense, it's not exclusive.
well,
It's
yeah,
exclusive to
except for the
each.
fact that I strongly suspect that the overwhelming majority of consumers will not see the restaurant as being this is a restaurant branded with Ape 2337, right? They will see it as that's the Bored Ape restaurant.
Right. You're 100%
And
right.
now we've got a problem because imagine that this new Bored Ape burger restaurant in New York City decides they want to open a franchise in Brentwood.
Okay, so that's an easy exercise. Imagine that the burger joint in California was phenomenal, but the one in Florida gave everybody salmonella, right? So, like, how do you deal with brand control in that situation? Especially when nobody knows how to distinguish between one ape and another.
That's right. That's right. So there's all of these questions about how you allocate these brand and I think these are pretty basic questions. Like, at the end of the day, it's Yuga Labs that is the brand owner and Yuga Labs that's sub-licensing the brand to their NFT owners. And only Yuga Labs is in a position to mediate the relationship between these sub-licensees. They're non-exclusive licensees. They can't do it themselves when it comes to the brand, right? So how do you go about apportioning market share and whatnot when it comes to the branding, right? What's more is, and this usually isn't such a big deal, but I do worry a little bit about problems like naked licensing when it comes to like they're not exercising, as far as I can tell, a huge amount of like quality control over who's using the brand and for what.
So this is a great point, and this is something that I've been struggling with lately. I'm advising a project right now, one of the early NFT projects that have very goodwill around their IP. It's a great collection, and there've been a lot of requests from the community to start commercializing and using their IP, but not a lot of guidelines from the founding team as to what and how they should or could do that. So I've been working with the team, and we're just kind of trying to think together what's the best way to empower our community to use this IP in a way that will be beneficial for the community as a whole, for the founders, and without getting out of control. So we've given a lot of thought to kind of drafting brand guidelines, if you will, as to best practices for using the IP. But there isn't a really great way to enforce this or control it, and I could easily see it getting out of hand. So I don't have answers. I just have a lot of questions, but this is something that we're struggling with, and I'm sure that there are other projects that are. Well, I think it's a healthy problem in the end of the day.
Yeah, no, I agree. I mean, I think it's a doctrinal problem in a lot of ways, or a practical problem as well. But I also think, like as you were alluding to earlier, the nice thing about it is there's a huge amount of potential synergy between the brand and the people using the brand. They build off of each other, I think, in really productive ways. And in some ways, I think it's a failing of our body of copyright doctrine that it doesn't contemplate brands being used in that collaborative, like really radically collaborative kind of way, which could be really beneficial, right? And good for consumers, good for businesses, and so on. So it seems to me that there's value in thinking about how we can accommodate these kinds of new social uses and creation of new social value in this way. If the law can't do it yet, the law ought to kind of evolve to facilitate that and to think about what the law can do in order to make that work more efficiently.
Okay, we'll leave it to the to the legislature to figure it out. Nothing will ever happen. Okay, so I want to quickly segue to another topic. I know that you taught or teach charity law, which I don't know all that much about on the legal side, but I have been working with a lot of nonprofits lately who've been interested in coming into the Web3 space. Particularly, it started with them just wanting to receive donations in crypto, but I have an organization here in Israel that works with children with disabilities. They do some really, really amazing things. They basically said to me after a few months, okay, now we could accept crypto donations, but we don't really understand or know anything about these communities and these technologies. We want to learn more. So we put together a phenomenal event in Miami just under a month ago. And I don't know if you've ever been to any like crypto NFT conferences, but they're all pretty much the same. There's a lot of like regurgitated content, always the same people, same conversations. But we decided to put on an event that was a little bit different. And basically the title was From Gaming to Giving, How Crypto and NFTs Could Be Leveraged for Charitable Purposes and for Impact. One of the ideas that came up was incentivizing artists to work into their revenue share a percentage that they would, pledge to give to a charity. So if 5% of revenue share is going to creators, so 2% of that would go to X charity perpetually. I wonder on your thoughts on that, and also having a background in charity law, you have any other suggestions or ideas as to how we could utilize these technologies to better the world?
Yeah. So I mean, like I taught nonprofit organizations, which I like to refer to as charity law. There's a couple areas where I've been really interested, and actually I would say that a lot of my scholarly interest in NFTs actually grew out of my interest in charity law, specifically about 10 years ago when crowdfunding was first introduced. I wrote it pretty extensively about kind of the economic kind of realities of crowdfunding and what it told us about the charitable sector. And in a lot of ways, I think the NFT market is actually very deeply related to the crowdfunding market. The difference is that it added speculation, which made it kind of revved it up considerably, right? The big problem with crowdfunding was it was hard to incentivize investment because there was no return on investment or no potential for a return on investment, except insofar as you get kind of warm fuzzies.
Which is why I thought that equity crowdfunding was a great step up in that direction, because the incentives through Kickstarter were not great. I can't tell you how many projects I bought into that went nowhere. But once you're getting
and I think and this is what kind of I observe, is that in many respects, I think the NFT market as it currently exists is functionally a form of equity crowdfunding, right? Insofar as when you buy NFTs, what you're really buying into is the future of a brand. and the belief that the brand is going to be more valuable in the future than it is today. So from a practical standpoint, I think that the NFT market accomplishes something in a really simple fashion that's complicated to do in the kind of traditional way. And I think that's one of the part of the power of the NFT market from a capital generation standpoint. A couple other things I think are kind of potentially interesting in the charity law space. One, obviously, is the rise of interest in DAOs, right? And I think there's a lot of potential crossover between DAOs and the charity law space, especially insofar as, a lot of DAOs are significantly, if not entirely, directed toward what are, broadly speaking, charitable enterprises. I think that in a lot of ways, what DAOs reflect is an interest in more direct governance relationships between the people participating, like the audience for a charity, and the charity's actual activities. And I do kind of wonder whether, and I don't know really much of anything about Israeli charity law, but in the United States, historically, there was a distinction between membership governed charities and board governed charities. And there was a very long trajectory of phasing out membership charities in favor of board governed charities because of the ease of a self-replicating board, facilitating governance decisions, so on and so forth. I think that the internet, broadly speaking, and Web3 and the innovations that kind of led to the creation of DAOs might revitalize the viability of membership-based charitable organizations in an interesting way, to the extent that people who want to be engaged in charitable activities also want to have more involvement in the governance and decision making of the charity around what it's going to do and why. So that could be a kind of, potentially anyway, interesting long-term structural change. We'll see if it goes anywhere. I haven't noticed a whole lot yet, but I think the charitable sector moves pretty slowly generally, especially when it comes to legal innovation. So I have suspicions that if it turns out that there's demand from people engaged in charitable activity for that kind of involvement, then DAOs could be an effective way of doing it. So I think there's a lot of interesting crossover though, and I think the charity law perspective has always been helpful for me, as well as kind of keeping my toe in the water a little bit as to advising clients and engaging in kind of on the ground practical legal activity, which I think is healthy for legal academics.
Yeah, I think the problem with DAOs as an alternative governance mechanism is that today, if you want to have, quote unquote, real DAO, because the term DAO gets thrown around just way too lightly. I can't tell you how many times I've bought an NFT and joined the Discord, and they're like, "Oh, welcome to the DAO." I'm like, "Whoa, this is," and nobody signed me up for that, for joint unlimited liability with the rest of you guys. So I think most DAOs, as they are today, are not DAOs, but for a charity or a company that's looking to structure a DAO in the form of a foundation and to do it really like properly and to be regulated, it's expensive. And so the cost of being compliant and structuring these things in a manner that's going to allow you to build something viable and sustainable down the road is just too costly to be a real alternative for nonprofits at this stage.
No, absolutely. And I couldn't agree more that, the big limitation on what I'm proposing and or kind of seeing as a possibility for at least some organizations down the line does necessarily, by its very nature, require a kind of acceptance of the inability to engage in profit taking from the enterprise, right? I mean, if you want to form a charitable organization, it means you're not going to be able to take equity back out of the organization later, right? The anything deposited, anything given to the organization will have to remain its property. But I think that might still be a viable option for at least some activities, if not necessarily all of them, and maybe being able to distinguish between which kinds of DAOs are actually structured as charities and which kinds of DAOs aren't, could provide a kind of helpful framework for thinking about what kind of DAO law, as it were, might look like in the future.
What else, man?
I mean, I'm surely I'm totally open minded. We can talk about anything of interest. I've got some new pieces. You mentioned that about resale royalties.
Okay, let me just briefly explain to anybody who's listening who's not like an NFT degen and doesn't exactly know what I'm talking about.
Yeah.
So one of the great things about the blockchain, and something that I've been advocating very strongly for as to why NFTs in particular are a great thing for creators generally and artists in particular, is that one of the things that you could write into a smart contract, which is basically a contract that says if A does B and C does D, then Y will happen, is the notion of creator royalties. So if I'm an artist and I'm creating an NFT, so I'm deploying, right? I'm putting the NFT on the blockchain, and I could write into the smart contract that from now and forevermore, anytime somebody buys this NFT, 60% of the proceeds will go to me, 10% will go to my wife, 10% will go to my dad, 10% will go to my mom, and 10% will go to my best friend. And that is something that will be dictated in the blockchain and theoretically should continue to exist forever and forever and forever and forever. However, recently, some of the marketplaces for the sale of NFTs have found ways to override this and have basically said, you know what? We think that these creators are being a bit overbearing with their 5 to 10% of royalties on secondary sales. We're going to change all that and we're going to make it optional. So now if you buy an NFT, you could decide if you want to give those royalties to the creator or if you want to keep them or the majority of them to yourself. Now, who in their right mind is going to give money voluntarily to a third party, even if they think the art is great and the artist is great? Not many people part easily with their money. And so what we've seen is many creators who were, had a steady flow of income from the resale of their art have basically gone back to not getting anything from the resale of their art, or just a very small amount, maybe 0.5%. And it's very much changed the way people have view the NFT market and blockchain technology as a means for creating and deploying and distributing art. And Brian wrote a fantastic article about this for a publication called Right Click Save As, basically discussing the pros and cons and also the history of creator royalties in the art market. Back to you, Brian.
Yeah, so I mean, I think the resale royalty observation for me grows out of grows out of the bigger picture kind of take I have on the economic realities of the NFT market. So, for quite a few years, I've been interested in the economics of the conventional art market, and specifically in relation between artists and collectors. And that's why I got interested in resale royalties, because it's long been a point of contention between artists and collectors, kind of jockeying for financial interests in future sales of works of art. And at least in the United States, collectors have basically always prevailed. And I would argue that even internationally, that's true as well, right? A lot of European countries have created statutory resale royalties. The practical effect has been is that collectors just don't sell their work there anymore. They sell it in the United States where they don't have to pay the resale royalties. And that it's easy enough to avoid. So what's the issue? A lot of artists tried to create private resale royalties. Effectively, contract law didn't really allow that to happen for lack of privity of contract between the artist and collectors on the secondary market. You can't enforce a contract against someone who didn't form it with you, right? That contract law just doesn't recognize
but
that.
I don't know, because I feel like smart contracts are different because they're proposed perpetuality. So I'm determining the terms of the contract from now until forever. And anybody who chooses to engage with that smart contract, even in 100 years, will have to agree to the terms of the smart contract. So um,
That's
I was
that's right.
actually
That's right. Although
ignorant,
I would,
thinking that all NFTs that were deployed on OpenSea were deployed with the royalties built into the smart contract. Only after I read your article, I understood that that's not the case. But to the extent that
yeah,
it is, there's no question that the platforms wouldn't be able to touch the resale royalties, correct? And then you wouldn't
that's
argue for
I
privity of contract because
right. That's
why?
right.
Why wouldn't you
That's right.
argue for privity of contract?
It doesn't matter, right? Because I think that the power of quote
Why
unquote
doesn't it
smart
matter
contract,
if your argument
because
that
I don't think
that
they're
anybody who's buying in the secondary market didn't agree to these terms stays the same, except
because
now
because
they
there's
can't touch the contract because I deployed it.
but the thing is, yeah, but the thing is, a smart contract isn't a contract at all because it doesn't require enforcement by the law. It operates automatically, right? So there's no
That's the
need.
argument that law is code,
Sure, right? Although I would say,
or code is law
I
rather.
like, yeah, right. I mean, I like that as a catchphrase. Although I think it's actually kind of misleading. I don't think it's true that code is law. Code is code, and law is law. And sometimes code is a more efficient way to accomplish whatever practical goal you want to achieve than relying on the law is going to be. If the law doesn't accommodate what you want it to do, then maybe you can rely on alternative mechanisms to accomplish the same goal. We have done that socially for a very long time, right? We enforce a lot of relationships or agreements socially, even though we can't do so legally, right? There are all kinds of illegal contracts, for example, that nonetheless get enforced because people have informal mechanisms, as it were, of enforcement. I think code is another way of accomplishing a similar kind of goal. I think the interesting question for me is, what kind of choices do people participating in the market make against the backdrop of code imposing obligations that the law doesn't impose? And I think that'll be an interesting question in the NFT marketplace, insofar as collectors have a choice between purchasing NFTs that have royalty payments, effectively taxes, really built into the smart contract, as opposed to ones that don't, right? And how those incentives on the back end affect what artists do when they create the NFTs in the first place, in the sense that if you know that creating an NFT with royalties built in to the contract, into the NFT itself, is going to disincentivize collectors from buying the NFT, right? That gives you a reason not to do that. And there are alternative ways of generating revenue, right? Like you can always just sell more NFTs, or you could charge a higher price upfront for NFTs that don't have a contract.
Yeah, but that's not sustainable as an artist as well. And if your assumption is that, I don't know, I thought that perpetual royalties was like one of the great things that NFTs brought to the market. I mean, this is empowering creators. I use it as a great use case all the time for why ticketing is a great industry to introduce NFTs, because yeah, sports clubs and theater clubs are losing a ton of money on scalper prices. But again, if somebody's going to come in and cut out the creators' royalties in the secondary market, then it's going to completely destroy that argument, and we're going to have to rethink the entire industry.
So, to my mind, the idea of resale royalties is a kind of relic of looking at the art market as a market for objects rather than a market for brands. I think the art market has always been a market for brands. When artists are selling artwork, what they're always really selling is effectively an investment in their career, right? But I think it's been hard for people to see that because the objects got in the way, right? And the objects made people think.
I've heard you say that on a number of different occasions. I don't agree with you because I think that there's two schools of thought here, okay? Or not two schools of thought, but rather two ways of relating to the issue. I know that there's two types of art that I would buy. I would either buy art because it resonates with me and because I want to display it on my wall and because it makes me feel good. And I'd either be willing to pay a premium because I love it so much, or, looking to buy it at cost because I'm cheap and I want to get something that looks nice on my wall but isn't too costly. And then there's art that is from the other school that you're talking about, where I want to buy into a brand, okay? And I would argue that there I would still only buy something that I resonate with, either resonate with the art itself or resonate with the message that the artist is trying to convey. But I would say that there are probably people who bought Bored Apes that they don't like, but because they were close to the floor and they wanted to, quote unquote, ape into this project because they wanted to be associated with something that they think is going to go to the moon. But I think that that's a small camp. I don't think that the majority of people who are buying art are doing it because they're buying into the artist brand or because they think that the artist is going to be great someday. I think that they're buying art because they resonate with how it looks and how it makes them feel.
For sure. No, and I 100% agree that a very significant part of the art market, as it were, is people buying art as a consumption good. And that's totally fine. I don't have any, I obviously don't object to that. I think it's great. People should like art and people should want to consume art. And if they want to buy art as a consumption good to hang on the wall and appreciate themselves with no thought to the potential or even expectation that the art will have, that their art they're purchasing will have a value on the secondary market, I think that's good. It's also realistic because 99.9% of art that's sold to consumers has no value on the secondary market because nobody wants to buy it at the price at which it was sold or any other price for that matter. Right? When I talk about the art market, the conventional art market, I'm really only talking about the market for art as investment. And I think that can be, and usually is, bound up with aesthetic appreciation of the work in question. But, no one pays $100,000, $1 million for a work of art or an NFT for that matter, if they, without the belief that there's at least the possibility, a reasonable possibility, that the work that they're buying is going to have at least some value, if not a higher value, on the secondary market.
Yes.
In the future. So in that market, there's always
at those prices. I agree with you.
There's always an investment element, right? And that's the market that I'm ultimately really talking about and interested in, because I think that that's the market that offers the possibility for speculation and capital formation. Right? The other market is great, but I think we've had that market for a long time, and I think its potential is limited. Right? Because people's interest in buying things as consumption goods is, they have a limited appetite for that, and it's hard to.
By the way, I think NFTs have helped the market mature in that sense, because anybody who belongs to the old camp is gonna right-click save as,
right.
But anybody who really wants to buy into art for this message that you're trying to convey is going to want to buy it on the blockchain.
That's right.
And
That's right.
I could tell you that for myself, I've collected, I've amassed quite a bit of NFTs in my collection. Still, anytime that I've right-clicked save as and printed something out and hung it on my office, on the wall in my office, because because it's a piece of work that I can't afford to buy. There's like a twinge of pain in my heart that I'm like, look, I like it, but like it's not, as opposed to like the cheap crappy NFTs that I have in my hidden folder, which I'd feel proud of if I put them up on my wall, because this is something that I have real ownership over. So I do think that the NFT market has helped the market mature towards the market that you're referring to.
Yeah. So and I think that that's really an interesting and exciting development, because I think, interestingly, the kind of art market economics are uniquely appropriate to a technology that makes information abundant rather than scarce, right? So when we make ownership of works of authorship not about control over the consumption of the work of authorship, but about a share in the commercial goodwill and the clout associated with the brand that created the work of authorship, all of a sudden you make it not just easier, but actually synergistically mutually beneficial to encourage as much consumption as possible, as opposed to artificially restricting consumption, which is really what copyright is all about, right? I mean, copyright is about like creating deadweight losses, right? I mean, the entire purpose of copyright is to say you're going to charge above market clearing prices, above marginal costs for whatever it is that you're distributing. I think that's a shame if we don't have to do it anymore. And if we can transition into a creative marketplace, of every kind, right? Where people can consume willy-nilly, whatever they want, whenever they want, however much they want. And that is beneficial not just for the consumers, but for the creators as well. I think that's a huge benefit to everybody. That's solving market failures right there in ways that I think would be really, really positive.
Thank you so much. I really enjoyed this conversation.
Yeah, me too.
Yeah. Do you mind just telling your audience how they can get in touch with you? I know you have like a million links.
Yeah. Well, I'm on Twitter at Brian L. Frye, BrianLFrye. You can also find me on YouTube at Brian L. Frye. Ipsedixit podcast is IPSEDIXIT. It's available at all the relevant podcast outlets. And you can email me at BrianLFrye, BrianLFrye @gmail.com.
Thank you. This has been a fascinating discussion, and I look forward to having many more together.
Awesome. Anytime. I'm always delighted. It's great talking to you, C.
Thank you for listening to Beyond the Code. If you enjoyed this episode, make sure to subscribe, share with your friends, and to tune in again next week for more fun and insightful conversation.